Good morning, everyone. Thank you so much for your patience this morning. Notice of this meeting has been posted online for at least 72 hours. Staff present today are Melinda Ramos, Trey Qualls, Brendan Utterback, Francisco Vega, Karen Moreno, Stacy Jones, and Denisha London. Chair, will you please call this meeting to order?
Yes, thank you. This is Whit Woolman, and this meeting of the Board of Adjustment will now come to order. It is the 11th day of March 2026, and I welcome everyone to the Board of Adjustment. This board is a citizen board appointed by the City Council. By state law, a minimum of 9 members or alternate members must be present to provide a quorum in order to conduct business. Today, we have a quorum with 10. Today's meeting agenda can be found online at www.fortworthtexas.gov. Speaker registration forms for cases on today's agenda should have been turned in prior to the start of this session. Today's public hearing is being documented by cable television and video conference recording, which will be available on the city's website. To facilitate an orderly meeting, I'm asking everyone in the council chamber to turn off their audible alarms on your electronic devices at this time, so we will not be distracted during our meeting. Each case will be called in the sequence listed on the agenda unless otherwise directed by me, the chair, which we just have one. The Board of Adjustment requests the following rules of procedure be respected. Each case will be introduced by the City of Fort Worth Development Services Department or city staff. After presenting the facts of the case, the Board of Adjustment members will have the opportunity to question city staff about the case and any applicable laws or regulations that might apply. This portion of the discussion is exclusively between city staff and the board members. As the case is being called, we ask that you move to the front row of the chambers. You will have 7 minutes to present the facts of your case and why you believe your application meets the criteria for approval. If more than one person is presenting the case, it is necessary to divide the total 7 minutes among all parties so you do not exceed the allotted time. After the applicant has presented their case, I will call for any opposition to come forward. This is their opportunity to express why they believe the variance or special exception in this case should not be approved. The opposition is also allotted a total of 7 minutes of time to be shared among all speakers. If opposition is presented to the variance or special exception, the applicant will have an additional 3 minutes of rebuttal time. The chair may allow a few more seconds in each presentation to ensure a speaker's final point can be made. After the parties have presented their positions, the board members will then have the opportunity to ask questions of the applicant and any opposition. During this time, all speakers must remember that all dialogue be directed to the Board of Adjustment only. There is no time limit during this period. After the board members have received answers to their questions, I will close the public portion of the hearing. Board members can discuss the case amongst themselves and city staff to determine whether or not an application meets or does not meet the criteria for approval. After this discussion, I will ask for a motion to approve, deny, or continue the case. City staff will call for a voice vote from each member. If an application is denied, an applicant will have 10 days in which to appeal to a court of appropriate jurisdiction. For more information on this and additional information on any case on today's agenda, you may contact the Board of Adjustment at 817-392-8026 after this meeting. If necessary, a closed executive session may be held with respect to the posted agenda items to enable the Board of Adjustment to receive advice from legal staff. Our first order of business today is to listen from the Deputy City Attorney, Melinda Ramos. Thank you very much.
Good morning, board members. As the chair said, my name is Melinda Ramos. I'm a deputy city attorney here with the city of Fort Worth, and I'm going to be sitting with you today for this appeal. So this appeal is unlike your regular cases that you hear related to special exceptions or variances, in that appeal is coming in up from one of our design review boards, for this specific instance from our downtown design review board. So I'm going to provide you some training and some background on that. Just by a little way of more background for myself, so you all know, for up until 2022, when I have my current position, I sat with the land use boards, but particularly the Board of Adjustment, probably for about 17 years. So hopefully I'll be able to provide some helpful information to you all as we go through this training. So just for a little background on the Downtown Design Review Board, they are appointed by the City Council. They are a board of 7, and they have alternates that serve on their board as well. They have the duty and the authority to enforce the downtown urban design standards for new construction and renovation, signage, and hearing applications for certificates of appropriateness is what they issue when they approve a new project or signage or any cases that come before them. They also hear, to a certain extent, waivers from their design standards and guidelines. So when they approve waivers, those do not generally come to the Board of Adjustment. They also have the duty and responsibility to propose amendments to the downtown design standards, to the Zoning Commission, and then ultimately to the City Council for approval. Their membership is typically comprised of architects, urban planners, downtown residents, downtown business owners or managers for downtown, and real estate professionals. The ratio of that can change on the board over the course of the years. So this is just a map to show you the overview of the area that is subject to the downtown design review standards. It goes all the way from the southern edge of 30 all the way up almost reaching into Panther Island, but not quite Panther Island. And they have different character zones within that, but the portion that's before you today is more along the freeway. So this is basically going to go over with you the hearing procedure of how this hearing will go, because as I said, it is different than your normal cases that you hear from the variances and from, excuse me, the special exceptions. So this is not a hearing that you will hear kind of de novo. It comes to you fresh and for you to make a fresh decision. These appeals are really based on the record that was made at the, in this case, the DDRB. So this is kind of an overview of how the chair will call both the city and the appellant and what is to be presented during that time. So initially, the chair will call the city. Typically, it's the form-based code administrator for that particular design district, and they will give only a case summary. There will be no arguments made in this overview. Part of what they'll include is the certificate of appropriateness, or COA is what it's typically called, that is requested, the applicable design standards and guidelines that apply to the particular request, the recommendation that was made by the staff, and then the decision that the DDRB board members made at that hearing. Once that is done, the chair will call the appellant to make their presentation. Their presentation should be based on the DDRB's record. It must show a lack of substantial evidence to support the DDRB's decision. That burden of proof is on the appellant. No new evidence is allowed to be entered in, and the appellant has 7 minutes by which to present their case. Once those 7 minutes are elapsed, then the chair will call the city. It's called the, oh, I need to change the slide so y'all can see it. The city response, and they will present what evidence is on the record to support the DDRB's decision, and that has to also be based on the existing record. They also have 7 minutes. Once their 7 minutes is concluded, each party gets 3 minutes to present their final arguments to the board. At the end of those 3 minutes, the chair will close the public hearing, open the board for discussion, and then a motion and vote. Part of your requirements in your motion that is in your rules of procedure that's right before you is the first motion that you have to make and to vote on is whether or not the decision of the DDRB was reasonably supported by substantial evidence in the record. Depending on how you vote on that, then informs the next motion that you all will make. Just to go over the standard of review, so the burden of proof is on the appealing party, who has to establish that in the record that there is substantial evidence in support of the DDRB's decision. Kind of, what does that mean? What does that test mean? So the test is whether or not it's supported by evidence on which they could have reasonably based their decision. It's did the DDRB act arbitrarily without regard to the facts? The test is not whether the DDRB came to a proper fact conclusion on the basis of any conflicting evidence. The Board of Adjustment can't substitute your own judgment for the judgment of the DDRB. It has to be measured on the weight of the evidence of the questions that were committed to the DDRB's discretion. So what was within their authority to decide on and how they decided on that. You all are not to stand in the shoes of the DDRB. So the Board of Adjustment should sustain the decision if it was reasonably supported by substantial evidence. So there's no firm definition of substantial evidence, but there is a mere scintilla of evidence doesn't suffice to support their decision. And so by scintilla, it's a minimal or slight amount of evidence. If the evidence is such that a reasonable mind could have reached the conclusion that the DDRB reached, then the DDRB's decision should be affirmed. So kind of what constitutes new evidence? And so the board really shouldn't consider any new evidence that is outside of the record that was made before the DDRB. Part of what you will need to do is determine whether new evidence that may be presented today, if it was available at the time of the DDRB hearing. Your inquiry on that should be confined to the conditions that existed at the time that the DDRB had their hearing and that they acted. As part of considering new evidence, you don't have to consider incredible, perjured, or unreasonable evidence on the record because that evidence isn't substantial. I don't think that's really going to be an issue for you all today, that last bullet. So if you all determine, though, that this new evidence was not available at the time of the DDRB hearing, then it is recommended that the case be remanded back to the DDRB so they can consider that in their decision-making. If the board determines that the evidence was available at the time of the hearing, you may continue, but the evidence may not be considered as part of your decision. So possible motions that the board can make, once you get past that first motion of whether or not there is enough, the decision was reasonably supported by the substantial evidence, then you can, if you decide that there is, then you can move forward to either uphold the DDRB's decision, reverse the decision, or remand the case back to the DDRB for further review, particularly if there's new evidence that's presented. This is kind of a basic flow chart of how the hearing should go. So the chair will call again the staff member who will give a overall summary just of the case before the board. If you decide that the evidence was presented and it wasn't previously available at the DDRB, then you should remand to the DDRB for their further consideration. If you find that their decision wasn't supported by substantial evidence, then the board can reverse or you can remand. That is also still an option for you. If you decide that it is supported by substantial evidence, you can affirm in whole or in part. So really that's the summary of all of the training, and it's something unusual for the board. I know you don't hear, and even during my tenure, we didn't hear that many cases from the Design Review Board, so I know it's something new. And what I would encourage you, though, is to keep separate your usual role for special exceptions and variances, because the test that you apply to cases for those does not apply here. It is strictly based on the record that was made at the DDRB's hearing, and what you're deciding is based on that. If you all have any questions, I'm happy to answer them. We can't talk about the specifics of the case because those will be presented during the actual hearing.
And these are more rules and procedure questions, right, about the appeal? Please go ahead, Ms. Duffy, or did you have a question?
I do have a question. I'm not sure it meets with the standard you just, so the decision being made in this case was about, there were two waivers. Can you compare and contrast what a waiver is for DDRB and what a variance is to us?
So essentially they are the same thing. It's just a different nomenclature.
So it
is
requires
it
a
is a
hardship?
request. No, it does not require hardship. but it is a request to vary from what the development standard or design standard is for that district. So for the design review boards, waivers that they consider are not reliant upon whether or not there is a hardship. The review is for those design review boards, whether or not, if the waiver is going to be impactful to the intent and purpose of the design standards for that area.
And can you compare and contrast? So the number one thing is, can they have it or not? Is it, I can't remember what they called it in the nomenclature, but basically, it's, to me, it appeared kind of like a special exception is on our board. It's a yes, or this exists in the zoning code, but it has to be blessed by the board. Is that the same in the case of whether?
So for certain design districts, certain projects can be, and it's written into their design standards and guidelines, can be approved administratively by staff. Whether that's new construction, or if they want to put a sign up, or if they want to put landscaping in. Some districts their design standards are written to give staff administrative authority to do that. Other design districts, like the Downtown Design Review Board, there are certain structures or elements or projects that if you want to do them, you have to go to the DDRB to get approval to do it. So if you want to construct a new hotel in the downtown area, you have to take your project to go to the DDRB. That project may not have any waivers that they're asking for, but their design standards require the hotel to go to the DDRB to get a certificate of appropriateness to make sure that the design of the building, the layout conforms to the intents and purposes for the downtown design overlay. So it's different from, it's a little bit more expansive than what comes before the Board of Adjustment. So with the Board of Adjustment, when you hear with the variance, it's because the property owner has some issue and they can't meet the setback, they can't meet the minimum yard requirement, and they need to get a variance from the board to do that. It's not necessarily anything related to the design of the house or the design of the fence necessarily. So the DDRB considers more aesthetic kind of concerns, and they have more aesthetic things that they look at in terms of how does what's being requested fit into the purpose and intent of what the district was created to do.
Ms. Freed, Ms. Duffy, are you okay? Are you satisfied? Okay, Ms. Freed.
Um, I'm confused about a point, and that is that maybe I misheard, but as you started the presentation, you said that the presentation should include what was presented before.
So
So
what will
where does the
begin,
new-
how your hearing will begin is the chair will call the staff member to come up, and they will provide a case overview of what the DDRB heard at their hearing. So it'll be what the appellant requested, what their request was. It'll be, if I can go back.
Just a note, we did provide all the information from the DDRB to you guys in the meeting docket. So you have the case report that was presented as well as the transcript that was prepared by district court.
Right, so the case summary is just a case summary. So there's not going to be any argument for or against what the DDRB decided. It'll be just, this is what was presented to the DDRB. This was what was requested from the DDRB, and everything that the DDRB decides gets a certificate of appropriateness. That's just the nomenclature for what they get. What the applicable standards and guidelines were that the DDRB reviewed as part of their hearing, what the recommendation was from staff was related to that request, and then finally, what was the decision of the DDRB. And then that really is the sum total of what's being presented for the case summary. At that point, the chair will call the appellant up, and the appellant will be provided 7 minutes to present their argument as to why there's a lack of substantial evidence in the DDRB's record to support their decision.
Okay.
And particularly with regard to any new evidence presented, that's where kind of really the board will have to make a determination if this new evidence, is it new, really?
Is it new or was it
Was it,
in the record?
was it
before?
available, could it have been available at the time of the hearing that the DDRB held, whether they made their decision?
Thank you.
Ms. Freed, are we coming back to you? Ms. Duffy, what about you? I know you still have questions.
So, back to the variance thing, just one, so does this carry forward, if they get a waiver, does it carry forward with the building? And I guess, did the leasing sign have a waiver already?
So the prior sign, I think, predated the regulations that were
Regulations came
applied.
into effect in like 2007 or something?
So with the Crown of Building sign, those didn't come effect when the district was created. Those came after. So prior to that, there weren't the same limitations on the Crown of Building as currently exist. So I believe the prior sign was there before. But
would
once it gets taken down, then any new sign that goes up has to either comply with the requirements, or they have to go to the DDRB to seek a certificate of appropriateness and a waiver.
And the variance carries, how does a change in ownership of the building affect this case?
So the change of ownership wouldn't affect, it's my understanding that the appellant is a tenant in the building, but had the permission from the property owner, the building owner, to bring the case forward, and that would be the same for any case that's presented.
And would that decision, our decision, carry forward with the property or with the tenant applicant?
So because of the nature of this particular request and this,
It's not, yeah.
it would carry with kind of essentially with the tenant, because the signage is dependent on who the
Specific.
tenant is.
Okay.
If it was the name of the building, then that would
It stayed
not
with,
necessarily be the
sure.
case.
And I think you might have covered this, but it's a simple majority. We have 10, so we'll need 6.
That's correct.
For any
If
decision.
any of your motions in the affirmative will need a 6 vote. So it's a simple majority of the members present. Your rules of procedure do say that if your vote results in a tie, that the motion is lost. I think with that, the net result of that would be is that depending on the motion and it's lost, we'd have to look to see what other motions are available to the board.
And you've kind of covered this, but with regard to how we classify new evidence, that's really up to us, it sounds like, in terms of if there's any new evidence presented.
Right. The real question for new evidence is whether or not that evidence would have been available at the time of the hearing before the DDRB.
Okay.
If it was available at the time, then arguably that is not new evidence and it should not be considered.
Okay. And then I have a question too, and this might be more case related, but with regard to how the motion carried on the initial case and how it got to us.
So the DDRB, kind of much like yourself, they have a set number of votes that are required in order to approve a case, and if you don't get that number, then the motion is lost. So for the DDRB, their minimum quorum is 5, and it results in a requirement for there to be 5 votes in favor. And so anything less than that will not result in a motion in favor. The motion will fail. And so the case will effectively be denied.
Okay, and I was reading in the background, and again, this might be more case related, but it was just saying on August 7th, 2025, at the meeting, a motion was made to approve. The motion carried with only 3 votes in support and 2 in opposition.
So
I thought it was
much-
interesting that
Yeah,
carried.
much like yourselves, if it's motions to approve that have a requisite number of votes that you have to meet or it fails. Motions to continue, motions to deny only require a simple majority of,
Got it,
of
okay.
the board.
So it carried, but there weren't enough votes at that time for approval.
If it's a motion to approve and it didn't receive 5 votes, then that would have been a denial. If the motion was to continue and it was 3-2, then the motion to
Simple,
continue
yeah.
would have been approved because it's a simple majority vote.
Okay, thank you. Yes, ma'am, Ms. King.
Yeah, with regards to new evidence, if there isn't, who makes that determination if there is an agreement among the board? Is that an individual determination or a collective?
So that's a good question. And I think there would need to be some consensus, or maybe perhaps that would fall to the chair to make that determination if there's not clear consensus on the board of whether or not the information is new. The board could decide to continue to hear the case, but each member would then be charged with how much weight individually you want to give to that evidence when making your decision. If the board does feel that there is new evidence and that it merits consideration by the DDRB, the board you have within your authority at any point in time to remand this case back to the DDRB for further consideration.
All right. Any other questions? Ms. Duffy, I know you're still pondering over there. You're good? Okay. Ms. Powell, did you?
Yeah,
Please.
I just wanted to make sure I heard you clearly. When it was asked about, tell me your name again.
Ms. King?
Miss King. When Miss King asked you about if there wasn't a consensus with the board,
I'm sorry, I can't hear you.
if there wasn't a consensus in regard to the new evidence, if who makes the decision? Could you clarify that a little bit more? Because I heard you mention the chair, but at the same time, each individual may have a different one, or we may all have one together. But if we have 3 different, 7 together, where does that lie? Or is the decision making?
So in terms of that, when I mean by consensus, it's just by the majority of the members present. So it doesn't have to hit a set number. But really, when you're looking at new evidence, to reiterate, the question is the evidence being presented to you as new, would that have been available at the time of the hearing before the DDRB? If the answer is yes, it would have, then that information should not be considered as part of your decision-making process. Should the board decide to go ahead and consider that information, it is up to the individual members of the board as to how much weight you want to give that decision in determining whether or not initially the first question of there is substantial evidence in the record to support the decision that the DDRB made. And then if you pass that hurdle, then whether or not you want to uphold and affirm the decision the DDRB made, if you want to modify the decision that the DDRB made, if you want to remand the case back to the DDRB. So really, kind of those are the options for you. If there is a true kind of paralysis of whether or not to consider it, that is when I would defer to the chair as the presider of the meeting on how to move forward with the case.
Thank you. I just wanted to make sure that was clear on record.
Sure.
Any other questions, clarifications? Okay. Thank you very much, Ms. Ramos. We are going to move forward with the hearing on this case. Are we ready to move forward with that, Ms.
I think your
Ramos, or-
hearing is scheduled at 10,
10.
but I think all interested parties are prepared to move forward, so yeah, we can move
Right,
forward.
let me check with Ms. London first. Let's take a 5-minute break, make sure we're ready to go, and then, oh yeah. So, Ms. Ramos. Ms. Ramos is complete with her presentation. We've gotten all our questions answered. We'll take a 5-minute break and then be ready to go in 5 minutes. Ms. Powell, does that work?
We can't start until 10.
Okay, so we'll be 10 o'clock.
And we have coffee and water right back here in the back, and we have light refreshments downstairs.
Okay, 15 minutes.
Good morning. Notice of this meeting has been posted online for at least 72 hours. Staff present today are Stephanie Scott Stims, Brendan Utterback, Trey Qualls, Melinda Ramos, Stacy Jones, Karen Moreno, Francisco Vega, and Denisha London. Chair, will you please call this meeting to order?
Yes, thank you. This is Whit Wallman, and this meeting of the Board of Adjustment will now come to order. It is the 11th day of March 2026, and I welcome everyone to the Board of Adjustment. This board is a citizen board appointed by the City Council. By state law, a minimum of 9 members or alternate members must be present to provide a quorum in order to conduct business. Today, we have a quorum with 10 members. Today's meeting agenda can be found online at www.fortworthtexas.gov. Speaker registration forms for cases on today's agenda should have been turned in prior to the start of this session. Today's public hearing is being documented by cable television and video conference recording, which will be available on the city's website. To facilitate an orderly meeting, I'm asking everyone in the council chamber to turn off the audible alarms on your electronic devices at this time, so we will not be distracted during our meeting. Each case, which we have one today, will be called in the sequence listed on the agenda unless otherwise directed by me, the chair. The Board of Adjustment requests that the following rules of procedure be respected. Each case will be introduced by the City of Fort Worth Development Services Department. After presenting the facts of the case, the Board of Adjustment board members will have the opportunity to question city staff about the case and any applicable laws or regulations that might apply. This portion of the discussion is exclusively between city staff and the board members. As your case is being called, we ask that you move to the front row of the chambers. You will have 7 minutes to present the facts of your case and why you believe your application meets the criteria for approval. If more than one person is presenting the case, it is necessary to divide the total 7 minutes among all parties so you do not exceed the allotted time. After the applicant has presented their case, I will call for any opposition to come forward. This is their opportunity to express why they believe the variance or special exception, or in this case, for sure, should not be approved. The opposition is also allotted a total of 7 minutes of time to be shared among all speakers. If opposition is presented to this variance or special exception, the applicant will have an additional 3 minutes of rebuttal time. The chair may allow a few more seconds in each presentation to ensure a speaker's final point can be made. During the question and answer period, after the parties have presented their positions, the board members will then have the opportunity to ask questions of the applicant and any opposition. During this time, all speakers must remember that all dialogue be directed to the Board of Adjustment only. There is no time limit during this period. After the board members have received answers to their questions, I will close the public portion of the hearing. Board members can discuss the case amongst themselves and city staff to determine whether or not an application meets or does not meet the criteria for approval. After this discussion, I will ask for a motion to approve, deny, or continue the case. City staff will call for a voice vote from each member. If an application is denied, an applicant will have 10 days in which to appeal to a court of appropriate jurisdiction. For more information on this and additional information on any case on today's agenda, you may contact the Board of Adjustment at 817-392-8026 after this meeting. If necessary, a closed executive session may be held with respect to the posted agenda items to enable the Board of Adjustment to receive advice from legal staff. So as we read through that, this is a little bit of a different case, a special meeting, and I'm going to have Melinda Ramos give us just an update based on what we talked about previously.
Right.
Please go ahead.
So, Melinda Ramos, I'm a Deputy City Attorney. I'll be providing advice to the board. I did want to clarify that this case before the Board of Adjustment today is related to an appeal from the Downtown Design Review Board, and so it will not follow the same rules of procedure that the board typically follows when they hear special exceptions or variances. In the instance case, because this is an appeal, the order of procedure will follow where it is an overview by the staff. The appellant will have 7 minutes to present their argument to the board as it relates to the DDRB's decision. The staff will have 7 minutes to present their evidence in support of the DDRB's decision, and then each party will get 3 minutes to present their final arguments to the board, at which case the chair will close the public hearing and then discussion will be had amongst the board and ultimately a motion. There is no outside testimony that is allowed for this particular appeal hearing. It is based on the record that was presented and made before the DDRB itself.
Thank you very much. Staff, would you please call the first case, which is BAC-25-056?
Yes, BAC-25-056 is an appeal from the Downtown Design Review Board decision in DDRB case number DG-25-026. The address of the property is 1612 Summit Avenue, and the applicant is Frank Sellers of Sellers Law Firm, PC. Francisco?
Thank you, Mr. Vega.
Good morning. My name is Francisco Vega. To provide some background about myself, I'm a licensed architect from Mexico with a master's degree in urban design, planning, and research. I've been working as the senior planner for the Downtown Urban Design District with the City of Fort Worth for around 3 years and 4 months. One of my roles is to review all private and public development, including and not limited to signage. And our role is to coordinate the Downtown Design Review Board, something similar to what my teammate Donisha does with the Board of Adjustment. And today I will be talking about this case that the Downtown Design Review Board heard last year. I will start with background about this case. Staff received an application for an installation of a sign back in May 2025. After staff review, it was determined that some waivers were required and a review by the Downtown Design Review Board was needed. Staff included the case in the next available agenda. The Downtown Design Review Board, DDRB, first heard case DG 25-006 concerning the installation of a chrono building sign and 4 requested waivers on April 3rd, 2025. At that time, the DDRB continued the case. The case was subsequently heard during the DDRB public hearing on August 7, 2025. The DDRB made a motion to approve the case. However, the motion failed, receiving only 3 votes in favor and 2 in opposition. As 4 affirmative votes are required to approve a certificate of appropriateness, the case defaulted to denial. No additional motions were made at that time. The proposed sign was presented again during the DDRB public hearing on September 4, 2025 as case DG 25-026. This is the case we are discussing today in this public hearing. The applicant submitted modifications to the original proposed chrono building sign, reduced the number of requested waivers from 4 to 2. Staff recommend denial, noting that the proposed sign does not align with the Downtown Urban Design Standards and Guidelines. During this public hearing, the applicant did not participate in the presentation of the case as they did not attend the public hearing after staff presented their report. The board discussed the proposed sign. They considering approving it, noting that other similar signs have been approved in the past, or denying it because it will clutter the facade by adding another commercial logo that serves no purpose other than announcing the business. A motion to approve the case was made and initially seconded. However, after City Attorney's Office requested clarification regarding whether the waivers were included in the motion, the second was withdrawn, and no other board member seconded the motion. Subsequently, another board member made a motion to deny the case, which passed with 3 votes in favor and 2 in opposition. The City Attorney's Office clarified that pursuant of Chapter 2.104F, motions to approve require 4 affirmative votes to grant a certificate of appropriateness, whereas motions to deny require only a simple majority. This concluded the last time this case was heard by the DDRB. Can we show the standards? So new signage and all signage in general is subject to meeting the Downtown Urban Design Standards and Guidelines. The specific chapter that talks about signage starts on page 49, and this chapter is divided in some sections. The beginning of the chapter talks about the intent and principles and the objective of what is expected for signage in downtown. As Melinda Ramos mentioned in the beginning, the intent and principles are something very important for the review of these projects within the downtown district. And specifically, after that, we have specific sections for different types of signs. Signage located at the top of buildings is what we classify as crown of building signs. So this sign qualifies as a crown of building sign. What you're seeing on the screen, page 68 regulates that specific type of signage. I don't think that I have to read all the applicable standards, but I will focus on some of them that are important for this specific case. One is the first paragraph that talks about the intent, and for this crown of building signage, it says that it just mentions that commercial logos and messages and the majority of taller buildings, the absence of commercial logos and messages on the majority of taller buildings leaves a clean, sophisticated skyline. And it says that this is a desire of the downtown community not to have commercial logos on all single buildings. Then for this specific case, some of the standards says it's more than 2 signs are prohibited. Signs shall have identical messages, and no more than 1 chrono building sign per facade is allowed, and a maximum of 1 horizontal or vertical line of letters or symbols are allowed. We have other regulations, but as you can see, we're very strict about crown building sign regulations. And the intention is that crown building signs should seek to become an architectural feature, an artistic representation of some sort, instead of just commercial logos. And so that's what these standards talk about. Another part of this background is the staff recommendation during the presentation of this case. I will read it. The DDRB staff recommends denial of the proposed sign. In reviewing the application, staff found that the overall scale and size of the sign may not be well suited for its location, and that the design does not appear to be compatible with the existing building. Staff also noted that the placement of the sign could draw attention away from elements of the facade, which the standards are intended to preserve. Based on this staff recommendation, as I mentioned, the DDRB made an initial motion. Ms. Dunn initially made a motion to approve the case, which was seconded by Mr. Blake. After Trey Claus with the City Attorney's Office asked for clarification regarding whether the waivers were included in the motion for approval, Mr. Blake withdrew his second, and no other board member seconded the motion. Subsequently, Mr. Burns made a new motion. Trey Qualls with the City Attorney's Office clarified that pursuant to Chapter 2.104, Section F, motions to approve require 4 affirmative votes to approve a certificate of appropriateness, whereas motions to deny require only a simple majority to pass. Accordingly, the motion to deny the case passed by a vote of 3 in favor and 2 in opposition. So just to reiterate, the motion, it was to deny the case, and it passed because 3 board members supported it and 2 were not in support, but we just needed simple majority to pass a motion for denial. So that's the background about this case. Are there any questions about this background for the staff?
I've got some questions, but we'll start with the stuffy.
I think it might be, this is meant to be an overview, so it might be appropriate to ask Mr. Vega his questions when he comes up during his portion of the presentation.
Okay. Are we at the point, do we need to?
Now we open it up to give their presentation.
So typically we can ask questions of the staff.
So this is, because this is an appeal, this is just a case overview, which Mr. Vega has provided. So the next point in the hearing is to call up Mr. Sellers
Okay.
as the appellant to present his case, and then Mr. Vega will come back to present the city's portion. And at any point during the appellant and Mr. Vega's testimony, the board can ask questions.
Sure, sounds good. Thank you, Mr. Vega, appreciate it.
Thank you.
Mr. Sellers, if you're here, please. You have 7 minutes to present the facts of your case. If you would state your name, address, and again, 7 minutes. Which one is better, left or right?
It doesn't matter.
Either one. Yeah. Thank you.
Who do I turn my form into?
If you'll hand it to Ms. Moreno, or Ms., there you go. Thank you. Yes, sir, please go ahead.
Mr. Chairman and distinguished members of the Board of Adjustment, my name is Frank Sellers. I am the tenant at 1612 Summit Avenue, Suite 200. And if it's okay with the board, the property owner, Nick Martin, is here. So I'll do this 7-minute portion and he'll do the 3-minute close if that's permissible.
Sure, if that's what you like to do.
Sure. I put together just a little presentation for you, and now that I've heard Francisco, I noticed there's one mistake. This is the building that we're talking about here. D&M Leasing sign up there is really a ghost sign. D&M Leasing has not been in this building since at least 2017. So before Mr. Martin bought the building, we signed the lease, and I don't intend to start a new evidence fight, but this is just a visual to represent what was presented to the board. And as the board was made aware, this was the lease term that was attractive to us when we moved into the building, that we could replace the D&M Leasing sign. So in May of last year, it really started before that. This has been a very long and winding road. But I want to talk about why we're here. D&M Leasing has not been there since 2017. We have presented this. Our sign company, I think, has quit on us at this point. We were just talking about that. But they went to an initial hearing and did a presentation. And that's where we were asking for the 4 variances. At that point, I think Mr. Martin started to buy the building, and he offered to jump in and help us out. And he convinced us all that the sign needed to go down to 2 variances. So we were asking for, more than 2 lines of text, a variation to allow for a bigger than, what the building size would allow. Took those out, made 2 lines of text, and the only other variance besides 1 to 2 lines of text that we were seeking was to be able to have 2 different Crown of Building signs on the same building. Now, I put up here 3-2 both times in favor of Sellers Law Firm. I want to point something out. For 5 years before the second hearing, which is the appeal that brought us here, these hearings were conducted on Zoom. So we were at the second to last hearing, but then they moved them off of Zoom and you had to be there in person, and it was in the fine print, and both of us missed it. And so that's why we were not able to present. But all of this has been presented to the board prior to. So we came back. We tried to comply. We tried to find a compromise, find a common ground that would appease the city and get rid of the ghost sign to help achieve what the Downtown Design Review Board is designed to do: remove visual clutter. And when we have, this is the hearing that we came back to. Master sign plan we provided. They said we didn't have one. We chopped down our variances request. This is the building from the other side. As you'll note, the purpose, if the purpose is to reduce clutter, you cannot see both signs from the same side of the building. You have to be on one side or the other because of the unusual shape of the building being kind of, I don't want to call it a triangle. I mean, there's a lot of different sides. I don't even know what kind of gone we would be here. But and I want to note that the first picture in the presentation also shows that there was a Lone Star Ag Credit sign that was in the middle on the silver part. That's gone. So we're down to 2 signs. One is Ameriprise Financial that is on the west side of the building, and the other is the D&M Leasing sign on the east side of the building. Here is what we propose. Remove the D&M Leasing sign, replace it with this, a crisp clean, brand-new lit sign that will look like the white part, like the facade in the picture in the middle there during the daytime, and like the black one at night. That is what we're proposing to do. And as you'll note, you cannot see any other sign on the building. As it stands, D&M Leasing's sign is doing exactly what they're complaining about, exactly violating the purpose for why they wouldn't grant this waiver. If the purpose is to reduce clutter, we need to remove the relics. So hearing three, I put still 3-2 in favor. That's my mistake. I thought it was 3-2 in our favor still. As I noted earlier, we were not present at this, but still, we had 2 people voting in favor. We had a majority the first time at hearing 2, 3-2 in our favor. The second time, it was 3-2 against us. We're simply asking, and it requires 4 votes, which was news to us. I'd never been anywhere where you get 3-2 vote and you lose. And so we're simply asking you to do what a substantial portion of the first Downtown Design Review Board was willing to do by a majority vote here. And kind of the bait and switch that I wanted to highlight from this transcript. This is Leah Dunn, and she's one of the members, and she basically lays out, look, we told these guys, change your proposal, get us a master sign plan, come back to us. We did that. And then when we got back, we were met with arguments about emergency services. This would affect emergency services issues. This is like a staircase in an old historic building. A staircase in an old historic building has nothing to do with a sign on the outside. And I want to point out something that she said. So I made myself okay with the seller sign that it had come back. I felt badly. I was going to say no, but then they put the work in it. I adamantly said no to C and D, which was the 4 lines and the big sign. If I remember correctly, I made the motion to approve, and that's where I still am. That's where Ms. Dunn was.
About 1 minute left.
Yes, sir. The skyline. I want to talk. This is not a skyline issue. This is a west-facing sign as you're leaving downtown. If I may finish my last.
Okay.
Emergency services will be improved. This was what they brought up. But I want to point out D&M Leasing at 7th and Summit has 2 signs up. So if someone calls 911 and says, I'm at the D&M Leasing on Summit, there's 2 places this could send them. So this is not an emergency services issue. The last thing, we're willing to pay for removal. This could help the city achieve its long-term goal. And I believe you as a board have the power when you approve it to make that stipulation. So we're trying to help the board achieve what its goals are, and thank you for your time.
Yes, sir. Thank you very much. Appreciate it. I believe we moved to opposition at this point, correct?
Well,
We
it
wanna
would
call for-
call the city,
Okay.
unless the board has any questions for Mr. Sellers.
Can we come back to questions, or is this our
Sure.
only time?
I have a
to-
Nope,
Can
you
I
can
ask
come
a
back to
question?
questions if you'd like.
Go ahead, Ms. Duffy.
Mr. Sellers, I did watch the September meeting online. The August meeting and the April meeting were not available online. So my question is, were you representing the case at those 2 meetings, or who represented your case at those 2 meetings?
I was at the August meeting along with Mr. Martin.
Mhm.
The September meeting, nobody represented us because it was online, and I guess that's how
Right,
you got it.
that's one, yeah.
And then before that, the sign
The
company.
April one, sign company was
The
there?
Cowtown was there, but we've included them on all the emails for all this and no response anymore. So we may have to find a new company if we get what we're asking for.
Okay, thank you.
Yes, ma'am.
I had a couple questions too.
Yes, sir.
I've seen 2 different logos or 2 different proposals, and I guess I probably need clarification on which one is in our application, which one was in the Downtown Design Review Board. But there is this one, correct, which it sounds like from what you said, this is kind of the current ask, or this is what came to the Downtown Design Review Board. The reason why I ask is because there's another one in our packet or in the docket somewhere that has trial lawyers
Yeah.
underneath it. What was the change there, or which one?
Again, we were trying to
work with-
find some compromise, and so we took that out.
Okay, so
just
that's,
to get to 2 lines.
and that was a 3rd line basically underneath, right? That's what their issue, I can't remember, I'm trying to remember what the design looked like, but that's out of the question now.
Yes.
Okay. Thank you.
unless you say otherwise.
Sure, of course. Any other questions for the applicant? Yes, sir, please.
Mr. Sellers, on the picture that we
Can you
Mr. Johnson, we make sure that we can hear you, just make sure it's,
No. Is your green light on?
I'll speak up. Okay, here
there
it is.
Okay.
On the photograph to the right, where it says Sellers Law Firm, there's a red thing on the left of the Sellers Law Firm. Is that a logo?
It is, it is, sir.
You could call me Your Excellency or Your Honor.
Your Highness.
Your Highness. There you go.
Yes, sir.
Okay, that's my question. Thank you.
Any other questions?
Yes.
Go ahead, Ms. Powell.
Could you clarify again, because I'm gonna keep those thoughts to myself. What is the issue between you and the city with this sign? Your logo versus D&M leasing and your current logo that you want to put up?
Are you asking for my opinion?
No, I'm not.
Okay.
Because you shared, I read it in the late correspondence as well as you shared about Ms. Dunn. Is that-
Yes.
Okay.
The
Approving
issue,
the-
I think, is that they believe that replacing this sign would cause more clutter. That's how I understand it.
So they believe that replacing the sign will cause more clutter. But D&M leasing is no longer a tenant, correct?
Correct. And hasn't been for a decade almost.
The tenant is Cellular, is that how you pronounce that?
Yes, ma'am.
Law firm.
Correct.
That is the operation business of that building.
One of them, yes, ma'am.
Prior, it was D&M leasing.
As I understand it, they had almost all of,
I'm just asking. you.
sure,
Prior, it was D&M leasing,
that's correct.
and they had a signage on the building.
That's right.
It's no longer D&M leasing. It's Cellular's law firm.
Yes, ma'am.
And you're stated, the city said, or the issue is that they want to reduce cluttering. So what I'm hearing is there is a problem with you having your business logo on the building. But there wasn't a problem with D&M leasing logo on the building prior. I appreciate your presentation, but I'm not seeing why there is an issue. Any business down, whether it's downtown or over the city, has a logo.
Thank you, ma'am.
Thank you.
Any other questions, Ms. Powell? Comments?
No. No.
Anyone else? Okay, thank you, sir. Appreciate it. Stay close, because I'm sure we're going to have more questions. Okay, at this point, we're going to bring back up the city. Mr. Vega, if you would please come up. And this is going to be our opportunity from the board to ask questions of the original case or more about the appeal from, I just want to make sure we're clear on what we're able to ask or what we're able to.
Right, what Mr. Vega should be presenting is, as it relates to the record and the evidence, whether there is a substantial evidence to support the decision of the DDRB that is based on the record that was made before the DDRB. You can ask him questions to clarify that record that was made before the DDRB as it relates to what the DDRB reviewed.
So I do have a question very similar to my first question about the logos.
Do you want Mr. Vega to do any type of?
Did you
has
have
the
more
opportunity to
presentation? Did you have
present.
more to?
Yeah, I would like to show
Yeah.
some evidence.
Please, yeah, please.
Before showing this evidence, I will just focus on the transcript and the standards. I just want to clarify, I was told to clarify about the new evidence to make it easier for everyone. Mr. Sellers presented contracts. We do not present contracts to the DDRB. That's not necessary documentation because we focus on design and not really on the legality of the contracts or leasings or anything like that. We, in fact, try not to judge projects using the financial standpoint. So that way we keep our decisions very objective of what we think based on the design aesthetics and intent and principles of the standards. Um, we didn't show images about the building, the traffic living downtown. We show context images so the board understands where this building is located and all that. But the idea is to focus again on the building and not really how it's going to be seen for every single angle. Um, just to clarify as well, we always email notices to applicants where we let them know how they are going to attend them, how they can attend these meetings, what time, the locations. We provide emails, phone numbers, etc., so they can preferably call us to say, hey, I don't know where this meeting is happening, so we can address that. And just last thing, just to clarify, previous decisions do not set precedents on design districts. We evaluate each case individually based on what we are seeing and the evidence that we have for that specific case. Now, going back to the evidence to show, to support this, the denial of the case, as we can see, I would like to go to page 6 of the transcript. On page 6, staff reads the following to start at the end of their presentation, and it's quoting page 68 of the standards. With downtown revitalization, and architectural personality has emerged, distinguishing it from other cities. The absence of commercial logos and messages on the majority of taller buildings leaves a clean, sophisticated skyline. Preventing further instruction of commercial messages on the skyline is a desire of the downtown community. To avoid this visual clutter, signs shall not be allowed to dominate the skyline. Then I would like to go to page 11. As you can see, Mr. Burns is saying that he understands that the existing signage is not in compliance with the design regulations. And just as a side note, he's referring to the D&M leasing sign that Mr. Self presented. So we knew that that sign was not in compliance. And essentially what Mr. Burns is saying is not because other signs are not in compliance, we should be approving new signage that is also not in compliance. So he is suggesting that we should stick to the standards and just follow the regulations because that's the intention of having standards. That is also supported by Mr. Pham, who also says that he recommends sticking to the design guidelines and adhering to. That's well for him. And he thinks that his responsibility is to respect and honor the downtown residents and the downtown standards that is put in place. And just the recommendation that staff has made is what he is in support. So he's essentially saying that he's in support of the denial because the standards should be followed. And waivers are exemptions, not a rule. When we presented waivers or variances to the DDRV, we always explain to the board that we already try to work with the applicant to either reduce things that need to be reduced so they are in compliance with the standards. That typically takes, it depends on the project, but it could go from 5 days to a month, and there are other cases that are more complex that we have worked for several months. So, and then the final evidence is just to show you the standards. As you can see, it starts with the paragraph that I already quoted saying that commercial logos should not dominate the skyline. That's something that has been discussed heavily by the board and other cases that we have presented Crown of Building signs. They are not really fully on board of approving new Crown of Building signs. And if you take a look at downtown, you can see that we don't really have a lot of Crown of Building signs. And some of the ones that have been approved, they try to accomplish either becoming part of the architecture of the building or try to be more like an artistic representation or something like that, but not really having every single business to be announced in every single building.
About 2 minutes left.
Thank you. And then that is reaffirmed with all the standards. If you read them, you see that they are very restrictive. They do not allow more. They actually prohibit more than 2 signs. And just for clarification, when an item is not allowed, that means that the board, the Downtown Design Review Board, can still review it because it's just not allowed. So they can decide what to do with that thing. But when an item is prohibited, we do not even present it to the DDRB because a prohibited means prohibited. So no waivers should be granted for prohibited items. And you can see that all the other standards follow, saying that signs shall have identical messages, no more than 1 Crown building sign per facade is allowed, a maximum of 1 horizontal or vertical line of letters or symbols. And then we prohibit raceways, cabinet signs, or animated signs. Lighting is limited to internally illuminated channel letters and or halo lit channel letters or logos. Signs above 120 feet are not allowed, and they require a waiver that needs approval by the DDRB by default. We have reviewed several of those, and typically the most recent one has been on hold because the applicant knows that there's going to be, some sort of concerns about the location and all that.
30 seconds.
That concludes my presentation. That's the evidence. Does the board has any questions for staff?
Are we able to ask questions at this point, or do we need to go to a rebuttal or to the
Similar
Yes.
to asking Mr. Sellers questions, you can ask Mr. Vega questions.
Okay. I think we probably are going to have some questions for you if you just hang tight for a second.
Mhm.
Ms. Powell, I think you were first.
And just a reminder for the board is that you are hearing this based on the record that was made before the DDRB. This is not a case where it is a first impression for this board. So you are not being asked to substitute your own judgment for the DDRBs. You're looking at the record that was made to the DDRB.
Yes, Mr. Vega,
Mhm.
correct? You generalize the statement on Mr. Pham,
Mhm.
page 11. There are numbers next to each statement. So could you go back and point in the record
Mhm.
what Mr. Pham said, that you generalize?
Make sure and tell him which page, too, you're looking at.
I said page 11.
Page 11.
Yeah, because he,
Mm. So in page 11, Mr. Pham, on line 2nd, he's just saying, I got well, I'll start with Brandon, but could you, I know, Paul, you weren't here last month, but if you could explain and just summarize in a minute or maybe 30 seconds of why you vote against. The part that I was speaking in general is more like on page 13. It says, and for me, it's really, for me, sticking to the design guidelines and adhering to, I'm sorry, I mentioned, I'm reading line 10 on page 13. Well, for me, my responsibility is to respect and honor the downtown residents and the standards that is put in place, and just the recommendation that DFWI and staff has recommended. I do appreciate that input, and I take that into consideration the same time as, from a design standpoint, I do agree at the top of building, the crown in the building, it does need to have one message, and the design of the sign needs to be integrated with the facade, right? The facade of the building. And I do agree to just have one message. That's what I kind of was trying to read about what Mr. Pham said. So I was trying to say that based on these lines of text, what I think he's trying to say is that we have to stick to the standards, because he's saying that we should have only one message. He's saying that the design of the sign needs to be integrated with the facade. And while we don't have it on the screen, that's what the standards call to be an architectural feature to be integrated with the building, and that's what I was generalizing about Mr. Pham. Does that respond to the question?
You said what you have on the screen.
Mm.
Generalize what? No, it doesn't answer my question.
I guess I'm not understanding the question.
What you have on the screen, I understand what Mr. Pham is saying, but the question I'm trying to get also clarification of the rebuttal to that of what you stated.
Mm,
Miss Paul, I'm sorry. I think what Francisco is saying, when he gave his presentation, he was just giving a generalized overview of the dialogue between Mr. Pham and Mr. Burns, and that Mr. Pham wanted to stick to the design standards. And when Mr. Vega came up before, we had on the screen what those design standards are. So he was just referring back to the design standards outlined in the, here. And that Mr. Pham was confirming that we should stick to those design standards that are on your screen now.
yeah, that's correct. And so he's saying that no more than one chrono building facade is allowed. So I think that's why Mr. Pham is saying not to have one. No, I believe Mr. Pham is saying chrono building sign it does need to have one message. Sorry, one message, and the standard says signs shall have identical messages. So Mr. Seller sign is different from the another sign that is located in another facade. And essentially the standards want to have identical messages. So he needs a waiver because this message, the Mr. Seller's law firm message, differs from the other Crown Building sign. So Mr. Pham is saying we should stick to have identical messages and make those signs part of the architecture of the building. Um, I'm pretty sure that's what we're saying here with the transcript and based on the standards that you have on the screen.
And that is allowed, correct?
That is what, sorry?
That is allowed. The same, yeah, but I'm asking, that is allowed to have the same standard signs on both sides.
So he's talking about having identical messages. So not having identical messages is not allowed and requires a waiver. And that was one of the waivers that it was requested to the Downtown Design Review Board.
Francisco, with this question, I think Ms. Powell wants to know if the message that's currently on the other facade of the building, if that message was placed on the side of the building where Mr. Sellers is proposing his sign, would that message be allowed on this facade? Would it meet all the design standards, or would they also require a waiver?
It will be allowed because it will be identical. So we have the same design on both. And I believe the Mary Price Financial is only one line of text of letters, so it also meets the standards. I do not know this exact square footage, but as you can see here in the standards, we have different maximums. So from 18 to 100, the maximum is 100 square feet. So if they have less than 100 square feet, then they will be allowed and they meet the standards. So yeah.
So if that same message was presented on this facade, staff will have to review to make sure the square footage and the location is compliant.
Yeah, essentially.
Thank you, Ms. Powell. Ms. Freed, were you next? Did you have a question? Nope. Ms. Duffy, please.
So Francisco, Again, I don't have the video available or the transcript available from the August meeting. However, you start, in the transcript that we do have from the September meeting, the meeting starts on, I think it says page 3 in this transcript, where you start the meeting by stating that there was a technical issue with the vote at the August meeting, and that's why the case is being reheard. So my question is, when you left the August meeting and the vote was 3-2, was the applicant told they had gotten the waiver at that point? Did the board think the waiver had been approved at that point? What brought up at what point did it get put back on the September?
Okay, so yeah, after the case defaulted into denial because we didn't meet the minimum votes to approve it, what we typically do is we send to the applicant a decision letter, and the decision letter mentions in simple words saying that on this date, the Downtown Design Review Board review your application for the following, and the text is exactly the same as it was posted on the agenda, so they know what has been reviewed. And we mentioned that the decision was made too, and then we mentioned what was the decision, and we explained essentially that on the decision letter. Once the applicant received the decision letter, they started, I believe, the appeal process. And before following the appeal process, um, with staff discussion internally, we thought that they could have the opportunity to just present it one more time. Because since the motion defaulted into denial, we felt that the board could have the opportunity to review the case one more time and reaffirm either if they were in support or not of the case. So that's how we ended up presenting it again in September. Obviously, that simplifies the process, and the applicant agreed on presenting it again. So that's how we heard this case one more time. And I
So
just, yeah.
when you walked out of that meeting that day,
Mhm.
everybody knew it was denied, and the original decision letter said you don't get the waiver.
It was clarified that a simple majority was needed. It was just enough to deny a case. Now, since the applicant did not attend the public hearing, we don't really were able to tell him what happened. Typically, when the applicant is there at the end of the public hearing, once it's
We're talking about the September one now.
yes. So typically, in any other board public hearing, I'm sorry.
But
Yeah.
I guess my question, just to clarify, was on the August meeting,
Hmm.
3-2 sounds like good news. Like, at what point was the applicant told that's not good news?
At the when that happened, um,
Francisco, at the August meeting, once the vote was concluded, did we say on the record that the motion to approve this case fails, which results in a denial?
we'll need to review the minutes, but typically I read what happened and with the motion, if it was either to approve, deny, to continue.
I can't find the
just say-
minutes online, and we don't have copies of the minutes.
The reason for that is because we are focusing on the September one, and we provided all the information related to the September one. We did not provide anything before that. We just provided context about the other hearings.
Wouldn't it support your case if you had the minutes?
So for this case that's before the board today, we are reviewing the final decision of the board, which was to deny the case. So the September meeting is the one we provided the minutes for from that meeting, along with the case report and any information that was provided by the applicant during that September DDRB meeting.
But all evidence that would support this case should have been provided.
So staff is correct. This appeal is based on the September DDRB meeting and the record that was made at that meeting. And that is what this board should take into consideration.
Mr. Acosta.
Yes, Francisco, so if the objective of the city is to declutter and this sign is staying there for multiple years, what would be the difference between approving something new and maybe making sure they compromise to take it off when they move out or leaving this sign there forever? What would be, what is the city approach?
So if I'm understanding correctly, is whenever we approve a sign, what happened when that business moves to somewhere else?
Well, at this point, the DNM leasing has been there for multiple years,
Yeah.
and it's gonna stay there unless
Mhm.
something change.
Mhm.
So if it's not removed, it's still a clutter.
Yes.
So it's doing the same purpose as the new sign. Two
Mhm.
different companies, but at the end of the day, it's the same. It's showing something that the city wants to look clean, right? So what would be the approach if this is denied? How is there one helping the city somehow?
Yeah, that's a good question. Our role is very limited to the review of design of cases. We don't really enforce, we are not enforcers. Um, so I think that we do not have the Downtown Design Review Board and staff on the zoning section. We don't have the ability to, try to remove signs that once they are not, in compliance or whenever the businesses move or anything happen. Um, Probably there's some mechanisms through building code, compliance, or something like that, but we don't keep track of businesses, for example. We just review the design of what is presented to us, and we just make sure that those designs meet these design standards and guidelines, the intent and principles, and that's the end of our process. Now, all signage requires a permit. That's a following step. So I'm not sure if in the permitting process they have the ability and they track down all these businesses and all that. But from our role, we don't do that essentially.
Thank you.
I've got a question real quick too, and sorry, Ms. King, if you don't mind if I jump ahead. So it sounds like from the August to September meeting, the staff made an administrative decision to put them back on the September meeting.
Mhm.
And could you describe what led y'all to do that? Was it an internal discussion?
Yeah, absolutely. It was an internal discussion with all the teams, with the BOA team and the DDRB team and the zoning team, and essentially we determined to offer that alternative to the applicant just to present the case one more time before proceeding with the appeal, and they agree on doing that. And that's how we included the case in the agenda. It was not my decision; it was a decision made with the team.
Is that typical? Does that happen where you can review with an applicant or?
To be honest, this is probably one of those first time that we are doing when the denial happened and it was continued again. Typically, the applicants work with staff on the design and trying to reduce all waivers and trying to meet the standards as much as possible. And only if there is a reason why they really need a waiver or a variance, or because the standards specifically said that that specific thing needs to be reviewed by the DDRB, we include those on the agenda. So in this case, they they presented several options to staff, but they still needed those waivers. So that's the reason why it was not something that the staff could approve administratively. So we offer it again to the applicant to present it one more time to the DDRB to hear their case.
Okay. And can I ask the same question about the logo? So in our docket, there was Sellers Law Firm, I believe, with trial lawyers underneath it. And then it looks like in their application, or what we've seen here, is they just want Sellers Law Firm with the logo. Is that new to this case, or was that something that you reviewed before, or you've worked with the seller or with the applicant?
Mm,
prior to this. Does that make sense? I'm trying to understand it. I just saw two different logos that we've seen, and I want to make sure nothing changed in the course of the way we've seen this or the course of the process.
yes. Um, yeah, what you see now on the screen, this is what we presented to the DDRB in September. So if we use as reference like what it was first presented back in April, the design changed, but still they needed the waivers. As you can see, they have different, more than one line of text and letters of symbols, and that was one of the waivers. And the second waiver is the message is still different from the other one that is existing on the other facade. Can we go back to?
And so even though they changed the design, and it sounds like they changed it with you guys talking
Mhm.
to the design review board, they still needed those waivers over the process of working with you.
Yeah, as you can see in the standards, it's mentioned signs shall have identical messages. So this it was for sellers law firm here, and on the other facade, on the other side of the building, there is an existing side. I think the business is Ameriprise Financial. So there are two different messages, and also no more than one. I'm sorry, a maximum of one horizontal or vertical line of letters or symbols is allowed. So they have two with the letters, sellers, and then law firm
Mm.
at the bottom, and then even vertically they have the logo on one side and the name of the business on the other side. So they need that
They still
variable.
need, yeah. So,
Yeah.
but the trial lawyers edition, that was kind of the initial application to you all, and then they worked with you to drop that and
Yes.
change that. Okay.
Initially it was for waivers because they were also, I think, exceeding square footage, the maximum square footage,
Okay.
and something else I can remember at this moment. But then they revised that design and made it a little bit smaller,
And
and
came
they
back
just
with the
needed the
two.
two
Yep.
because of the nature of this, because it's a new business,
Sure.
they cannot meet these identical messages, and also because their design has those lines of text and logos, they needed the waivers.
Okay. Thank you.
Mhm.
Ms. King.
Um, yeah, I guess I'm kind of confused because why don't you, and let me know if my question is appropriate at this time. The purpose of a crown signage
Mhm.
is to identify the building or the tenant.
Um, I'm trying to revisit already on the standards.
And that was my next question. And is it in the standard in terms of what the signage or who the signage should identify? And if that information was considered anywhere in any of the initial uh, hearings?
Yeah, I'm gonna show you the intent. So for all signage, as I mentioned at the beginning of the presentation, the signage chapter starts with the intent and principles of signage, and then it has different divisions for the type of signs. So technically, all signs, no matter which one, which type, is subject to this intent. And the intent is to establish to encourage creativity and innovative approaches to regulating signs. Sorry, that's the intent of the standards, but to encourage excellence in signage, both as communication tool and as an art form, to enhance the economic value of the built environment by avoiding visual clutter, which is potentially harmful to property values and business opportunities, to allow and encourage creativity and unique sign designs while preventing clutter and unattractive streetscapes, to ensure signs reinforce the existing and envision character and are complementary to the architectural design of the downtown. So they don't really have the objective of, like naming buildings or something.
But that's the broad term signage, but we're talking about crown signage. And is there a distinction with that kind of signage?
Crown of building signage is also subject to these principles. All signage in downtown is subject to these principles. There is, in the Corona building signs, oops, we have a paragraph at the beginning of the standards, and it says, with downtown revitalization, an architectural personality has emerged, distinguishing it from other cities. The absence of commercial logos and messages and the majority of taller buildings leave a clean, sophisticated skyline. Preventing further intrusion of commercial messages on the skyline is a desire of the downtown community. To avoid visual clutter, signs shall not be allowed to dominate the skyline. So if we are talking about a specific intent for current building signs, I think it's this paragraph. And it's not really saying that we want to identify buildings or anything like that. It talks more about how signs should be, an artistic expression or something that is part of the architecture and not really just a commercial logo and just that.
Okay, well, I'll just say for the record that we're not agreeing on that at this point because I'm seeing the distinction of the crown signage being that different uh, than just the broad term signage
Mhm.
that you're pointing to. But nonetheless, you've answered my question.
Okay.
Because in reading the information that was provided before the meeting, I think that that issue in and of itself was one of the reasons why there was a disagreement among the panel, that the standard pointed to um, the standard pointed to not having lost my thought. Never mind.
We'll come back to you.
Okay.
Yeah. Mr. Riley.
I think I know the answer to this, but was the applicant or their representative present during the September hearing?
No, they were not present.
Did the rule change for no video conferencing change during this process? From the first application to this last, or to the first consideration to the last consideration?
I can respond to you, Mr.
Yeah.
Riley. The answer is yes. The city manager's office made a determination that all the city's boards and commissions would begin to meet in person. And that applied to both not only the board members, but the applicants and anybody wanting to speak as well.
Now, I know it impacted the Board of Adjustment because we used to have individuals that would video in, and we had a
Right. Now,
Correct.
that was a decision made by the city manager's office that was then applied to all of the city's boards and commissions, not just exclusively the Board of Adjustment or the DDRB. It was across the board.
The last question is probably of staff also is, did the downtown design guidelines change from what we're seeing here from when this process started till the end?
Are you referring to when
These,
are you referring to when Mr. Sellers made the application, or are you referring to when the D&M leasing sign was erected on the building?
I'm talking about the application.
Okay.
When the application was made. Was there any changes to the downtown design guidelines?
From April to September.
Correct. That affected.
Okay. No, no
Design.
changes were made to the standards. Yeah.
So the Downtown Design Review Board was acting on the same rules from the time in which it was initially applied for in April and when the final decision was made in September.
That is correct. Yeah. Same,
Thank you.
same standards.
Yes, ma'am, Ms. King.
Okay. The reference was at the prior meeting that the building sign does not meet the zoning intent. So if you modify a non-compliant condition, shouldn't you bring it into compliance?
So are you asking in order to bring it into compliance, what would have been required for the
Right,
signage at the
right.
crown of the building?
Right.
Do you understand the question, Mr. Vega?
So what the applicant needed to do in order to make the sign compliance with the standards?
Right.
Yeah. Um, that's a complicated one because the sign differs from other signs in the building, and that sign is already existing. So if this sign is different, completely different, just it's a different business, it, it's impossible to make it in compliance fully with the standards because this message, this business sellers law firm is different from Ameriprise Financial. So there is no easy way. Now, when staff cannot make decisions and cases vary from the standards, that's the reason why we present those cases to the Downtown Design Review Board. So the board can make those determinations and it's not staff based only on what we have. So they hear the application, they discuss the application, they hear staff's recommendation, and then they decide between the board what to do with the application, if it's appropriate or not.
Well, it sounds like you've thrown it back on us, and I understand, but it's not in compliance with the DM. I think that's what's up there. You take that down, and then you put it up, put something up that also is not in compliance with the standard. So that's where I'm confused.
That's what it was
That was
denied.
the issue, that was the waiver to the DDRB, was whether to allow another sign that
And
is
they
not the
voted not
same-
to.
Is not the same, that's correct.
And that's, okay.
Exactly.
Clear.
So they differ from the standards as well as the existing DNM signage.
All right.
So the board heard the case and made the determination that we shouldn't be allowing more signage that is not in compliance. And that's the reason why the motion was to deny the application. Yeah.
Can I ask, what point of the process are we in right now? Are we still in a rebuttal phase?
So this is not, you have not entered the rebuttal?
The
form?
rebuttal, so the applicant still has time.
Right.
On his rebuttal.
Correct. 3 minutes, and then we can then continue to ask questions after that, right?
So, well, I would recommend that you can ask questions, but each side will, after Mr. Vega is done, will have 3 minutes of rebuttal each. So Mr. Sellers will be able to, Mr. Sellers, or I believe he deferred to the building owner, will be able to come and offer a rebuttal. And then once he is done, Mr. Vega can come back to the podium and offer the rebuttal on the part of the city and for the DDRB.
And then as I understand it, we can,
And do we have a discussion period before the vote then?
Right.
So once the rebuttal periods are over, the chair will close the public hearing and then open the floor for discussion. The matters of discussion are related to whether there was substantial evidence in the record to support the decision of the DDRB. And then once you all make that determination, then there are remaining motions to follow as to whether to uphold the decision, reverse the decision and modify, or to remand the decision to the DDRB.
and as I understand it, during that discussion, we can also ask questions. We can still,
If it is necessary to your discussion, you may ask
To-
questions to both parties.
right, to our board discussion. Any other questions for city staff right now on their presentation? Okay. Thank you, Mr. Vega. Appreciate it. The applicant, or the parties associated with the applicant, you have 3 minutes. If you would, please come forward, state your name, address. Thank you.
Good morning, Board. My name is Nick Martin, 6467 Crestmore Road, and I am the owner of the building. We purchased it last year in June, and through the due diligence process, speaking with prior ownership, I know that this sign issue has been going on for, I would almost say 2, maybe even 3 years, with conversations with the DDRB to try and get this right. When I first came in, so I understood that in April, It was first proposed, so Cowtown Signs created a presentation, proposed it, and there were 4 variances at that time. So when I came in, I took a look at that, and before going back to the board and representing something, I wanted to understand where we were. So actually, during the summer months, we actually worked, Francisco and I worked fairly closely with the sign company, with Mr. Sellers, to reduce the number of variances being requested and basically get it more into compliance for what the DDRB really would like to see. We went back and forth multiple times, multiple iterations, finally came up with something that there still were 2 variances that were needed, which would be 2 separate signs on different sides of the building, and we found that relatively acceptable because of the shape of the building. It's atypical. It's got kind of 2 different angles, a couple of different angles there. And the other one was we reduced it. We took 2 of those out, and the last one was on 2 different layers. So you have Sellers Law Firm. Just because of the side that it's on, we couldn't really get rid of that variance. So through the rest of the process, and I really want to take it back to, for me, it really kind of comes down to fairness. So we worked with the city, we got something, actually Francisco and I thought, hey, this is great, this is going to pass. And one clarification, with the Downtown Review Board, there's actually supposed to be 7 seats with an alternate that should fill that in. So in the August presentation, only 5 people showed up, which actually was detrimental to us because that means that 4 out of the 5 people that were present would have to vote for our variance. And that was one of the reasons why we got 3 out of 2. We thought it passed. We were celebrating. And then Francisco clarified, no, you need 4. So I said, oh, well, that's not fair. We discussed, and we were online during that time, we discussed and say, well, let's present again next month in September. Maybe more people will show up. Well, the same thing happened. And unfortunately, this was a mistake on our end. On September 1, they cut off all access.
30 seconds.
And so we were not even present at all. We were ready on our computers to be there, to talk. No one was there on our side. And then during that September meeting, again, 5 people there, 3 for, 2 against. And there was an email that Francisco sent afterwards that clarified the DDRB initially made a motion to approve the case, but the motion did not carry with 3 votes in support and 2 in opposition. Some of the board members opposed the motion because they believe crown of building signs shouldn't include commercial messages.
Go ahead and finish your thought. Yeah.
Anyways, someone decided that, well, if they're not here, let's vote again against it, and we can pass against the variances if we only have 3. So one individual, we weren't there to represent ourselves, and they flipped, and we lost. That's the story.
Okay.
So,
Yep. Thank you.
any other questions?
Can I open up to the board for questions at this point? Staff, is that okay? Yeah, please. Any questions for, yes, sir?
I have a question. If this case is denied, if the signage is denied, what do you plan to do with the current signage on the building?
It's a good question. I'll have to consult with my tenant first because we did sign a legal document, an amendment that states that he can put something up there.
We had heard safety concerns,
Yeah.
emergency service issues and things like that. So
Yeah.
it seems like it would be something that would be.
I know he wouldn't pay to have it come down. At some point, I would probably have to pay to have it come down if there's any other future options. I know in the discussion with Mr. Sellers, if he got his sign up at this point, he says, well, if I ever leave, I'll take it down. And that is an issue, ongoing issue with most commercial buildings is once that tenant leaves, they're out. They don't want to have to pay to have that sign come down unless it's written into a document that says that they have to.
Typically, isn't the main tenant of the building what's represented on the top of the building?
Ameriprise?
Yeah.
On the far side?
Right.
Yes, and they're still there.
Okay.
Yeah.
Thanks.
Any other questions?
Yeah,
Please.
I have a question. I don't believe it's for the applicant, but it's on this particular board, it's 7 members, correct?
On the Downtown Design Review Board?
There are 7 appointed positions to
Right.
the DDRB.
Right.
Their quorum is 5.
The quorum
The
is 5.
required vote needed to approve is 4.
5. And 5 was there.
Any other questions for the applicant? Okay.
Thank you
Thanks,
very
sir.
much.
I think we now bring up the
Mr.
city
Vega?
staff.
Yeah.
Yes,
Yes,
correct.
rebuttal.
For 3 minutes.
Yep. Just to clarify, when we post the agenda, and after that we create the staff reports and presentation and prepare all documents, we send what we call courtesy notices to all applicants. And in this case, we explained to them that there was a change in how they could attend the meeting. So we told them that they needed to be in person here in the work session room. So we certainly provided that information, just a clarification. And also, yeah, as the Nick mentioned, we worked together, and when they bought the building, he collaborated with us and tried to adjust the design of design and all that. And we found that the waivers that they needed were reasonably, and that's the reason why we listed the case again on the agenda. Again, because one of those is just impossible to me. Like, if you are going to have a different business, you cannot have the same name of another business and the other elevation. And for the line of text of the maximum number of lines of text of or logos, it's also reasonable because their name of the business just is that. They evaluated other options where it was just like a line of text and all that, but I think that it was really small. There were some issues with that sign that at the end of the day they decided to go with this one, that it was smaller and all that, but it still required those two waivers. And as Maureen mentioned, during that meeting we had a quorum with 5 members. 2 board members were absent. They had excused absences, meaning that they reach out to us and let us know why they couldn't attend. So we had enough quorum to make the votes. It's just that the decision was not unanimously. So that's the reason why at the end of the day was not really not received the 4 votes that they needed to approve. And I think that's all the information that I want to clarify. Every single other information about the standards and all that, I think it would just be repetitive. But if you have any questions about that, I can share it.
Okay, thank you. You still have a few more seconds if you have anything to add.
No, it's good. Thank you.
Okay, thank you. Yeah, hang on, Mr. Vega, stay up there for a second. We have some questions for you.
I'm just still trying to get my head straight about when these votes happened. So that vote that he mentioned was a 3-2 vote in favor of the signage, right? And then we came back and I see a vote now, 3-2 vote in favor to deny. So which is it? I mean, is it both? Do we have both votes?
So in the August meeting, the DDRB made a motion to approve, and it didn't pass because the minimum votes to pass a motion for approval requires 4 affirmative votes, and it was 3 in favor and 2 in opposition. So we didn't meet the minimum of 4. Okay. When we presented this case back in September, as you see on the screen, Ms. Dunn initially made a motion to approve the case, and there was a second to approve the case. However, once the attorney staff clarified as is this approval including all waivers, then Mr. Blake withdrew his second. So without a second, the motion couldn't carry, so we couldn't vote on it. Subsequently, another board member, Mr. Burns, made a motion to deny the case. And the motion passed with 3 votes in favor and 2 in opposition, because for denying cases, you just need simple majority. You don't need a minimum number of votes.
And this was the most recent vote.
This is the
3-2
most
in
recent.
deny.
3 in favor of denial, 2 in opposition of denial.
Thank you.
And just to clarify the question again, the board has 5 total members with 7 as alternates.
So the board has 7 members that are appointed, 5 members is necessary to create a quorum in order to do business. And in order to approve a certificate of appropriateness, it requires 4 affirmative votes.
And in attendance at the September meeting, there were only 5. Is that
Correct.
right? So they were essentially missing 2, as I understand it.
2 regular members.
2 regular.
And just because the numbers probably are not gonna, place 4 was vacant at that time.
Okay.
So we had 5 board members present, 2 absent, and 1 vacancy. So that gives the total number of 7 board members and 1 alternate. So in total, it's technically 8 members. It's just that one of them is an alternate and not a regular member.
But at the vote in September, 5 were present.
5 were present.
Right.
That's correct.
And could you describe, after September, it was denied, and then it came to us? Has there been any other hearing or any other review or anything of this since the September? So from that 5-person vote, they've then worked with you to come to the Board of Adjustment
They have been working with the Board of Adjustment
to be here
staff
today
Yeah.
Yes.
in September? Okay.
Yeah.
Okay, thank you. Any other questions?
Yes, I have a question, actually two. But when was the notice provided? Because, no.
Uh,
Yeah, when was the notice of, that they can no longer, they had to come in, person provided to them?
So we typically send out notices 10 days prior to the public.
Denise, I'm sorry, you'll have to let
Oh,
Francisco respond because this is in relation to the hearing for September. I mean, last September.
Sorry.
So just to clarify, we do not follow that rule of notices being sent 10 business days prior cases. We work differently. We just send courtesy notices. That's something that I mentioned at the beginning. And essentially, it's just an email to the applicant. It includes the agenda, and it includes all the steps to be how to be prepared to present the case during the hearing. It mentions the location, the room, the time, etc. And in that specific time, we included a paragraph saying that we were changing the way board members and the general public could attend, and we were switching from online to in-person only. And it was provided on September the 2nd at 8:39 a.m. So we provided the notification for the applicant.
You say it was provided when?
September 2nd,
And when was the meeting?
September 4th.
September the 4th, but the rule says a 10-day notice?
No, that is not the
No.
rule for the DDR.
I'm sorry, that's the rule for Board of Adjustments.
What is the rule overall?
We don't really have a rule about the notices, so we send courtesy notices. It's literally, we are just letting them know that the case is on the agenda, but we don't have a rule. The only rule we have is to post the agenda at least 72 hours before the meeting, and I believe then later that was changed to 3 business days, and we met that requirement.
It sounds like they differ from us
But
in that
my
way.
recollection as a whole from the city secretary and the training we've had, I believe it's a 72-hour notice. That's 3 days.
So that is the Texas Open Meetings Act that the city secretary is referring to. And there was a change in law in September that requires agenda postings to be done 3 business days before the meeting. And I believe Mr. Vega has indicated that they met the Texas Open Meetings Act. What I think you were asking about is the communications that staff had
He
with
said-
the
he
with
said
the
they-
applicant regarding the hearing and whether or not you could still video conference.
He said they sent a notice on the 2nd, and the meeting was on the 4th.
That's correct, and that's for
That's
notice.
only
That's
48
not the
hours.
agenda. He's not referring to the agenda. Is that correct, Mr.?
Correct. The
Vega?
agenda was posted on August
I'm not-
28th.
My question wasn't in regard to the agenda. My question was in regard to the changing from Zoom to in-person.
Yes, that's
So
correct.
that he can meet those, so that they would have had an opportunity to be in person if that was required because of the change.
That's correct. It was.
So you
sent-
didn't provide a notice where this company could have had the ample amount of time to be there in person. I'm not talking about the agenda. I'm talking about the opportunity to represent themselves if that's what they had to do, or send a lawyer, whichever the case is.
I think what
may
she's
be.
saying is maybe the Zoom change was too quick, 2 days too quick for them to plan to be there. Am I right, Ms. Powell, or am I on the right track?
Right, and they didn't meet the standard.
Just to clarify, the standard about the notices is 0. We don't have a standard about notices. If we want to meet
But
the
make
standard,
it make sense to me why this particular department don't have a standard about meeting criteria for someone to come and present their case
yeah,
when everybody else has a criteria, a standard. Make it make sense to me, somebody, and show it to me according to the
So,
law.
I can.
Show it to me according to the law, where you cannot have a standard to notify an applicant of a change.
So, Ms.
From
Powell,
Zoom.
if I could address, so the DDRB does not have any notification requirements. So what Mr. Vega has testified to is that the staff provides a courtesy notice to the applicants regarding the date, time, agenda, and in this instance, Mr. Vega said the change to the ability to appear in person
But
or by video.
do they have legal rights to
That-
only?
I'm sorry if I can finish, please.
Okay.
That is not something that is codified for the DDRB. So the notice that he is referring to is strictly the
But-
courtesy reach out that they do. So that is different than this board experiences with with your regular Board of Adjustment cases where that notice is codified in the zoning ordinance.
Again, my question is not being answered. I feel like it's being ran around a mulberry bush. There is a standard across the board, whether it's this design, let's just say it's someone is trying to get a patio. There is a criteria standard that they have to know when they have to be, at what time that meeting's gonna be, and there is a criteria standard of notification.
Right, and that is,
Y'all keep talking about what I keep hearing is about agenda.
no,
I'm
ma'am.
talking about,
Yes, I'm talking about the notice provision
okay,
also.
but you
and what
said
I'm
they
trying
have
to-
no, show
There-
me.
There's no
Okay, City
codified,
attorney, please, show me according to the law that they are not required by right to give them a fair shot to come before the board with proper notice. Because every other department, if I'm correct, has to abide by that. No matter what, even if you go to court, you got to, every applicant in that suit has to have notification.
so if I can address your question, this is strictly what is written, codified in our zoning ordinance. The DDRB does not have noticing requirements in their, either in their enabling act or in the main body of the zoning that talks about the district itself.
Can you provide?
Provided, however, if this board, it is within the discretion of this board to remand this case back to the Downtown Design Review Board to allow the appellant to appear on a date certain with the DDRB to appear in person to present their position to the DDRB.
Thank you for that, but can you provide that zoning ordinance?
So their enabling act,
There,
I believe it's 2.102, but I'll have to look that up. So if you give me a moment, I'll look up their enabling. So the, I'm sorry, the DDRB, their enabling act is 2.104. And the Downtown Urban Design District is in Chapter 4. It is a overlay district that is in 4.402. But just a reminder for this board, this is an appeal of the DDRB's decision to deny the case for the signage with the 2 waivers. And you all have to make your decision based on the record before you. You have discretion to remand the case back if you think it needs further review by the DDRB.
And right now, we're still in the question and answer. So Mr. Vega's in his rebuttal period. So we still have question and answer opportunity here. At that point, we will close the public portion of the hearing and have a discussion among the board. So right now, understand your issue, but let's make sure we get
But-
all the questions from Mr. Vega or the city, and then
Again, knowing the zoning ordinance and different requirements is still part of the review, which is before us.
sure.
Because this is a part of what they have presented is in both, was in the applicant's application. Mr. Vega got up, shared his rebuttal against it. So all of this is part of it.
Any other questions for Mr. Vega at this point? Okay. Thank you, sir. Appreciate it. Okay, so now we will close the public hearing portion of this hearing, and then I think legal is going to remind us, as we have our discussion about this appeal, there are two steps, so I'll let her.
Right, there are 2 steps that should be the focus of the board's discussion. The first is a determination of whether the decision of the DDRB was reasonably supported by substantial evidence. And then you all will need to make a motion and to vote to that effect. And then once you do, then I'll inform you about what your available motions are in that instance. I will say, if in the course of your initial discussion, if the board determines that remanding the case is the proper course of action, you can go ahead and make that motion if you would like.
Okay, so at this point, we're at the discussion and/or motion phase. And like she said, the first step is whether the decision of the Design Review Commission or board is reasonably supported by substantial evidence. Ms. Duffy, did you have something?
I have 2 things, my quick response to that is I'm not sure if I know the evidence of why the board turned it down necessarily. However, there is one thing, we got page 68 up. I wanted to point out halfway through that first paragraph, it says, preventing further intrusion of commercial messages on the skyline is a desire of the downtown community to avoid visual clutter. Signs shall not be allowed to dominate the skyline. I looked in the definitions in this same document that we've been provided, and there is no definition for visual clutter. I know that Mr. Vega depended on that quite a bit, but there's no definition for visual clutter, but I did find a definition for commercial message, and I want to read it real quick. A message displayed on a sign which relates solely to the economic interests of the advertiser and its audience, a message pertaining to price and product advertising, goods and services. So I just wanted to point that out. You guys
Right, and
haven't
just
read the definitions?
Right, and just a reminder for the board that you are not asking to hear this case de novo. You're making your determination of whether or not there was substantial evidence based on the record that has been provided to you all from the DDRB's hearing in September, and whether or not there is enough evidence provided at that hearing to support the board's decision of a denial.
But I believe what Ms. Duffy just shared is part of what we need to make a decision on whether they presented enough evidence. Again, as I said before, that's included in part of it.
Ms. Freed.
Yeah, I think there's it's difficult um, to stop ourselves from wanting to reevaluate this as if we are considering it. But if I look at what was discussed that day in September, just objectively look at what was discussed, all the different issues were brought forward. There was a lot of consideration as well to the efforts that were made to come closer to compliance. But in all of the votes that had happened, it came out that they just didn't meet the numbers with the design review board wanting to stay within the standards. And I think what really gets us, and I know that we have issues with this when we're hearing cases, if we could go back to page 50, if somebody could put page 50 back
Is that on the guidelines or on the?
on the signage guidelines, because this was discussed within within the meeting. And if you look at non-conforming signs, we have the same thing as we're looking at things. If something is non-conforming, it's because those guidelines weren't in place. It's essentially grandfathered in, just to use colloquial terms. So D&M leasing was grandfathered in. And if you're looking at trying to build, as this design group is trying to do, to build on, and yes, they are new guidelines, but to build an image of the city, to do something that makes Fort Worth unique. This is where what was discussed, and I don't know about the August meeting, but in September, this was brought forward that once the non-conforming sign is restored to the original condition, and there's where we have sort of a got you, because it hasn't been restored yet, it reverts to where you evaluate it as if that wasn't there before. And I didn't hear any new evidence today. So if I'm looking at very crisply and cleanly at what we've been asked to do today, I don't see an effort, a reason to remand it back. There's been the issue discussed of fairness, and I don't really understand, does the Notice of Public Meeting Act apply at all? That's a question.
No, it does not.
No, it does not.
Not to the purposes of what this appeal is and what the board's to consider.
Yeah. So I'm sort of at I really hear the issue of fairness. I really do. I really understand that, you get a long email in and you're like, oh yeah, we've got this. We know what we're going to do. We've got our plan. And so there was a miscommunication. So I have conflict. I'm just sort of babbling out loud here, but my conflict is if I'm just asked to do what we've been told our guidelines are. I didn't see any new evidence, but if the issue is the fairness and there's some concern that another shot at presenting the same material again, is that going to change things? No, I could be swayed.
So it sounds like you believe that it was reasonably supported by substantial evidence.
Yeah, I didn't see any new evidence today. The board came back to, we have an opportunity here to bring this building into compliance. And they decided that they wanted to stick to the standards. That's all I heard. I didn't hear anything new.
Okay. Mr. Acosta?
Well, excuse me. I truly believe they have the 5 members for quorum, but they didn't have, I don't want to say
6 or 7.
7 members where more people has the opinion, and also the fact that they were not present, that will give the impression to some board members they don't care. They're not here. So when you talk about really the facts and presenting everything, we have the same information, but there was only 5 people who were able to make the decision instead of the true 7 members when 4 has to be approving the decision. That is what I want to say.
And that's exactly where I guess the fairness comes in, because I know I have voiced many times on this board a concern when we only have quorum. Because when we have quorum, just one voice can change it versus having 11 people. You know, and I know it's difficult sometimes to get those people, but I think every effort should be made, and that it is better to have more voices.
But besides
My conflict comes back to, yes, but it's been multiple votes that came to the same conclusion. And if it goes back, is there any new evidence being presented?
Mr. Riley or Mr. Witten, sure.
This is Johnston.
Sorry, Johnson, excuse me.
If I was on the design review board, I may have voted for the waiver, but that's not the issue before us. If I was a city council, I might put some better rules of notice. But this is not the city council. The only issue before us is whether this board had before it sufficient evidence to justify its decision. And to me, it's absolutely clear. Just you take the fact that you've got 2 different messages on this building. That's a clear violation. And the board was within its right, in my view, to deny the waiver. The other things about the logo and so forth. Again, as I understand it, our purpose here is just to simply determine whether that design board had in front of it sufficient evidence to support its decision. And for me, it's clear that it did. And again, if I was on the city council, I might introduce an ordinance to say, in these things, we will have more notice or better notice. And if I was on the design review board, I may have voted for these waivers, but that's not our function. So that's where I am.
Mr. Riley, do you have something?
I'm along with Mr. Johnson. You know, what's been presented today, I don't believe that the design review board did anything in error. They based their decision on the evidence. And in fact, what really supports it is that legal staff was there and told them exactly what they were going to do, how their voting would impact this outcome. So it wasn't, and I get this idea, but I can't verify it. At the August meeting, that confusion was what led to staff saying, let's hear it again, and probably, I would say, anticipate that the staff communicated that to the applicant. So I'm with Mr. Johnson. I believe that they had sufficient evidence to make the ruling. Whether I'd make the same ruling or not, it's not mine.
Sure. Ms. Duffy?
My question to both of you gentlemen is, what is that evidence?
They've been presenting it for the last hour and a half.
I mean,
There's nothing that was wrong. That we didn't change the rules during the process. That's one reason I asked the question, did the guidelines change? No. Now, if they had changed from the time that they made the first application in April to when they made the decision,
but what?
I think there's legal, I'm not an attorney, I think there's legal standing out there. You change the rules in the middle of a process, you're vested back to the rules that when you made your application. But there was no change in the rules or the guidelines. That's my point.
Well, I mean, I'll add into that specifically. You're going to have you have 2 different messages on the same parapet.
But that's the waiver they were asking for. They
That
were
was-
asking for a waiver to that.
Exactly.
Rule.
And the board denied that waiver. And then the second one was one line. Again, we've got more than one line. The other is the logo. So those are, in my view, that was evidence presented that was in
Evidence,
violation of the parapet sign ordinance, and they would need a waiver. The design board decided not to give the waiver, but they had, in my view, a specific basis for not providing that waiver.
But if they had,
which was
had noticed,
commercial messages and visual, what are they, clutter. Do we have evidence of that?
So you all are not the determiner of evidence.
No, but was there
would've-
evidence at that
That would have
meeting?
been the DDRB, and the question for the substantial evidence test is whether there's enough evidence in the record. And this is because the appellant was not present. Is there enough evidence in the record based on the board's discussion to support their decision to deny the case? That is the question that is before the Board of Adjustment, and the only question that is before the Board of Adjustment.
is there enough
So
evidence?
the first question to the board, and it should be in the form of a motion, is there enough substantial evidence to support the decision of the DDRB? So there's a motion either that in support that there is enough substantial evidence, or there's a motion to say that there is not substantial evidence. That is the motion that is.
I understand that. I'm
needs to
just
come.
not seeing, and part of it is the way the design standards are written. There's nothing in here that says this is your evidence of whether you can or can't do this. So we don't have a lot to go on. But if we're trying to meet intent, I'm seeing the words visual clutter. Certainly Francisco used that a lot, visual clutter. It's not defined. Commercial messages defined, and I can find a definition for that, but I didn't see any
Right, and a
evidence
reminder.
that we
Reminder, you should be basing your determination and discussion based on the record that was provided to you, not any kind of really independent review at this dais. It's based on the record that's before you.
Right, which we were provided the transcript from the
That's correct.
September meeting.
That's correct.
Right, so if anybody sees any evidence in there, I would love to hear what you're seeing, because I don't see it.
Correct.
I have
Then,
a question. Was the applicant given the opportunity to postpone their hearing for the lack of votes that they would, like we do sometimes? We will let the applicant know that they could postpone, and maybe we'll get continuance or something along those lines.
So based on the record that's before you, because the applicant was not present, then the answer is no, the applicant wouldn't have been afforded that because they weren't present at the hearing.
Understood.
and the applicant wasn't given the opportunity to be present. So we don't have enough evidence.
I don't hear it.
Speak again.
The only reason it came to the September board, it had already been denied. So they've already gotten another chance, if you will. And what I see in the September meeting is that because of the legal advice, I look the way that the motion was made. The legal advised, it's got to be, you've got to have everybody on board except for one. It just legal was helped them refine the way that they did the motion to give them the most opportunity for approval. So the thing is, if I've got to think, if they'd been there, was there anything new provided? Was there any new evidence? And if I didn't hear any new evidence today that's not discussed in the meeting notes from September, I don't know what would have
Again,
changed if they'd been
yeah.
there.
Thank you, Ms. Deborah, but you're not persuading me. 1, 2, they have a right to be at the meeting, and they should have been notified. 3, the motion was approved. They was motion to approve until legal shared what they shared in regard to the, what was it, the variance, I believe. I'm trying to find it where I made a note. And once that was made, one of them withdrew, the board member who made the second withdrew. And so that, because of that, that brought about a change. Had they had notice to be at the September meeting, there could have been something that they could have presented, and it went back to the original motion for approval. Because they didn't have notice, proper notice to be there, they wasn't able to present again. So therefore, with that being said, there's not, in my perspective, there is not enough evidence because they was not even able to present in September.
Mr. Chair, if I can make a note.
Please.
So we are receiving notes from IT. Can everyone tell me or make sure that the green light is on your microphone?
Yes.
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 If the microphone, if we can't hear you as soon as you start speaking, just give it a moment. They'll resolve the issue. Please do not touch the microphone to turn it off and then back on again, or just make sure your green light is always on. Thank you.
And I'd like to say, I mean, to Ms. Powell's point, you know, a no-show could be taken wrong, you know, and we did see the vote change from a 3-2 to the opposite. You know, we went to deny. So that could have been taken wrong, you know. So I kind of see her point as far as that person not, or the applicant not making it to that meeting. It could have been a factor.
Mr. Costa.
I agree, because even if it was a denial, you got the majority, you got 3-2, and then in the final decision, you don't have a way to speak to the board, you don't have a way to present the facts. So they denied the case, but you're not present, there is really nothing you can do. So I think there is evidence.
Ms. King.
To our attorney, I guess I'm concerned that there is still confusion about what the test is. Is there another way you can state it so we can all get on the same page?
I'll try. So the test that is applied to the Board of Adjustments review of this appeal is whether, based on the hearing and what was presented to the DDRB, that there was enough evidence there that they could have made their decision, and that that a reasonable person could understand why their decision was made. And that's based on the hearing and the record that was presented to them in any discussion that board had in relation to their decision.
And that's all we should be
That
dealing with.
is the
at this
limit
point.
of this board's review.
I would just like to say, I'm very clear on the task. And within reviewing the task, there's not enough evidence presented because the applicant wasn't able to be present. So based off, again, as me and Mr. Hicks agree, based off of that, I'm not in agreement with this, and I believe it should be remanded.
So just as clarification, if we're done with discussion, we need a motion first on the board's decision was reasonably supported by substantial evidence. Then second, based on that, we need to do that first, then have a second motion. Right.
That's correct. So the first motion would be if a motion to say that there is substantial evidence to support the decision of the board, or a motion to say there is not substantial evidence to support the decision of the board.
So right now, we need a motion.
And either one's going to go on a majority.
Simple majority.
That's correct. Simple
majority.
majority.
Simple majority. Mr. Johnson.
I make a motion that the board determined that there was substantial evidence to support the decision of the Downtown Review Board.
Okay, can I get a second?
Second.
Okay, we have a motion and a second. Staff, if you would please perform a roll call vote.
Yes. Board Member Michael Johnston,
Yes?
Board Member Bob Riley,
Yes.
Board Member James Hook,
No.
Board Member Sandra King,
Yes.
Board Member Whit Woman,
Yes.
Board Member Lucretia Powell,
No.
Board Member Kay Duffy,
No.
Board Member Juan Manuel Acosta,
No.
Board Member Deborah Freed,
Yes.
Board Member Eric Ortega.
No.
I believe it's 5-5.
Yeah. So,
5-5, right? Yep.
Right, so
So-
so based on a 5-5 vote, then the motion to say that there was substantial evidence fails. Where the board is, according to your rules of procedure, then it would, since that motion is lost, then there's a finding that there was not substantial evidence to support the decision of the DDRB. So the motion now there's two possible motions that are available to the Board of Adjustment, is to reverse the decision of the Downtown Design Review Board, or to remand the decision of the Downtown Design Review Board to them for further review.
Right, so it sounds like because it was tied, we go now to what I'm calling C under 2AC. Because it was not reasonably supported by substantial evidence, right? That motion
Right,
is
because
lost, and
you had a tie vote, then it defaults that the motion that says that there was substantial evidence does not pass. So you are at where there is not substantial evidence for the board's decision. So, the DDRB's decision. And so there are two possible motions available to the Board of Adjustment. The first possible motion is to reverse the decision of the DDRB, which would be to approve the sign and the two waivers. The second option available to the board is to remand the case to the DDRB for their further review.
I have a quick question before I make my motion.
please.
Can we make a motion? The motion that's going to be made, can it be with stipulation that they have the required board members present? Because this board has seem like they can do things free will.
Well, I think this board is subject to the same kind of issues that the Board of Adjustment is that while you have a full complement of 11, or in that case 7, staff doesn't have the ability to have the full complement always appear,
And the threshold is quorum.
and the threshold is quorum.
So if they have quorum, that's what we go by. Same as
Okay.
us. Same as ours.
Right, it would be at the caveat to that is for any particular meeting similar to the Board of Adjustment, it would be at the applicant's discretion is seeing the number of members on the board and what's required to get an approval to ask for a continuance.
So,
Also, may I add notice in there, stipulation of 14 working day notice? Because again, this board, from what I've heard, has free will.
So if I understand you correctly, you would require that the staff for the DDRB send written notice to the
Yes.
applicant?
A written notice to the applicant as well as phone call,
Within a certain time period.
14-day notice.
That could be a stipulation of a remand. But I would caution that setting a set number of members present should not be a
so
part of that.
my
Remand.
opinion is that we are not the Downtown Review Board, and I don't really want to take something out of their hands, so I would like to make a motion that we remand this back for further review by the
Excuse me, Ms.
Downtown.
Duffy, I already said I was going to make the motion. That was going to be the motion I made. That's the reason why I asked in regard to the stipulations, a 14 business day notification, written as well as phone call.
I don't know if that was a full motion, though, Ms. Powell. I think you were
I
asking
was waiting,
questions.
we were still in discussion.
I
That was
understand.
my question.
I understand.
Okay.
But,
But
Ms.
again,
Would you like to make an alternate motion? Because then we'll vote on that first and that will go.
make a,
Ms. Freed, are you pulling back your motion at this point?
I'm offering her
Alternate,
to
okay.
make an alternate motion.
I would like to make a motion to remand this back to the DDR Review Board with the stipulation guidelines of a 14-day business notice followed with a phone call to the applicant for the hearing.
Second.
So we have two motions on the floor. We have a
So you,
primary and an alternate.
right, so the alternate motion will be voted on first, and if I could ask for one clarification with regard to the phone call, is when the motion maker would like the phone call to the applicant to occur?
Excuse me?
When would you like the phone call to the applicant to occur? Do you want it to occur a day before the meeting, a week before the meeting? When would you like that phone call to occur, to provide some clarity to staff?
The phone call to occur 72 hours before the meeting.
Okay.
I have another question about the motion.
And I believe, real quickly, Mr. Riley, were you seconding Ms. Powell's motion?
Yes.
Okay. Mr. Riley?
In her motion, she stated a 14-day business announcement, or a notice. So basically, that's, it'd be a 3-week notice if you're stating business
That's correct.
instead of a
Do
calendar.
you want calendar days or business days?
Business days.
Okay, just want to make sure that that's clear to the applicant and to everybody that's.
And by business days, you're referring to Monday through Friday, correct?
Correct.
And Mr. Hook, you're okay with that?
Yes. Yes.
Could we restate your motion, Ms. Powell, just to make sure we're all clear on what you're asking?
I'd like to make a motion to remand this case back to the DDRB board with the stipulation guidelines of a 14-day business day notification, a 72-hour phone call notification to the applicant.
Thank you. And Mr. Hook?
Second.
Still seconding, okay. Staff, we have a motion and a second. Could you please perform a roll call vote for us?
Yes, we have a motion by Board Member Lucretia Powell to remand the remand the case back to the DDRB board with the stipulation of a 14 business day written notification and a phone call to the applicant 72 hours before the meeting. The motion was seconded by Board Member Hook. Board Member Michael Johnston?
No.
Board Member Bob Riley?
Approve.
Board Member James Hook?
Yes.
Board Member Sandra King?
No.
Board Member Whit Woolman?
No.
Board Member Lucretia Powell?
Yes.
Board Member Kay Duffy?
This is the end of the line vote, right? There's not another vote after this. Yes.
Board Member Juan Manuel Acosta?
Yes.
Board Member Deborah Freed?
Yes.
Board Member Eric Artiaga?
Yes.
The motion passes to remand the case back to DDRB board.
Okay. The applicant, this case has been decided, so it will now go back to the DDRB, excuse me. I would work with staff as early as tomorrow, either be in contact with the Board of Adjustment staff, Denisha, or Francisco, and they can kind of point you in the right direction. Thank you very much for your time. Thank you for everybody's time today.
We'd be finished by 10 o'clock.